Well, hi folks, here we are again with some more comments and a short video lecture. As I do these over the weeks and months that I've been doing these last couple of years, I've started thinking of them as kind of like the things my parents told me about, which I know are way before your time. But back in the Depression, when times were really hard and people weren't sure how they're going to make ends meet and so forth, the president, which was President Roosevelt back then, would get on the radio and he'd have what he called a fireside chat. It's just a little short chat, tell a little bit about what was going on and what their efforts were and what they're trying to do. So basically what I'm just trying to do is let you know I'm a real person, I'm here for you, and I'm trying to help you. And so just kind of give you my thoughts on the material, so as you're fashioning your own, and we're each entitled to our own opinions, and it's not a problem, but I'm just trying to give you some hints and some ideas about the background of these certain cases and these situations. So today I'm going to talk to you on this one a little bit about stop and frisk. We've already talked about the Terry case in an earlier video that I made. And of course that's probably like the foremost case that anybody thinks of if they say, well, what do we mean by stop and frisk? And if you remember on Terry, he was kind of walking back and forth in front of a store, and it's 100 degrees in downtown Cleveland, which, if you've ever been there, I mean, it's hot in the summertime. It's like July, it's over 100 degrees, and he's wearing a raincoat in the middle of the day, and everybody's like, well, what's this all about? So this police officer watches him for a while, and he finally walks over, and he does a pat-down search on the outside of his clothes, which is for officer safety. And the officer only said that he just had a hunch or a reasonable suspicion. It's really a reasonable suspicion, a little more than a hunch, based on his years of experience, watching these type things, watching people and so forth. He thought he ought to inquire, and he's entitled to look into his own safety. So what he does then in a frisk is just outside of the clothing, under the arms, outside the coat, but he immediately noticed that there was a shotgun there. So the stop and frisk, not an arrest. Arrest will come up later, but obviously the stop and frisk is based on reasonable suspicion, whereas a full-blown arrest is where they're handcuffed, taken downtown, pockets searched, all this type thing. And that comes about when there is actually fully probable cause involved. So in this particular case then that we talked about, Terry is one example. We're going to share another one here with you in a few minutes. Important things to remember on this in terms of the learning objectives. This is a Fourth Amendment situation. These are brief, occasions. In other words, the police officer is not allowed to hold a person for a very long period of time. And then basically they just kind of look people over, and if they're sweating, why are they sweating? Well, it could be because you're wearing a raincoat in the middle of 100-degree weather, and why do you wear a raincoat on a day like, these kind of questions, and then while at the same time you're patting the person down and find a shotgun under their coat, So outer clothing only for the protection of the police officer, looking for concealed weapons. So in other words, no pocket searches, no looking in their cigarette pack for drugs or anything like that. That is not allowed unless there's more. And then the more that we're talking about is what we call probable cause. Other thing here is that warrantless searches, any kind of stop and frisk must satisfy two requirements, and that is that there is a need to kind of search the person that outweighs the invasion of individual liberty. In other words, in this case, officer safety, just double checking, and then facts and circumstances that can back it up. And so like I say, more than just a mere hunch, but it's a hunch based on years of experience and in doing a number of these different cases and seeing things that are out of order. The raincoat on a hot sunny day was obviously out of order, and so that led to a reasonable suspicion, and therefore he could do the pat down. Well, this is an ancient right of police to stop and question people. Of course, then you get into other parts of it is you don't have to really answer if you don't want to. And then the other part of it is that in the 1960s, there's what we call the due process revolution. That time period, I mean, there was a lot of work done to hash out, what are the limits, and, what are the sides of the envelope, basically. What can they do, what can they not do in stopping people. Police officers argue that they have a good judgment and they have professional experience, and so they should be allowed to, make these inquiries. Fourth Amendment kind of issues are brief detention only. Unless the officer finds something more, they've got to allow the people to proceed on their own. Also, frisks are just a once over lightly. Remember, no going in pockets, just outer clothing. You see a bulge in the pocket that feels maybe like a pistol, then basically you can inquire further. Other facts surrounding basically that, there's a lot of times that police officers frisk people that are unarmed. It's just one of those things for their safety. And so basically lawbreakers and law abiders in high street crime areas, for example, have totally different views. Many people feel like that especially in certain minority neighborhoods, for example, there's just a heightened level of these intrusions into people's freedom and time and safety. And so, that is a real fact, that police do seem to do more of this in minority neighborhoods like blacks and Latino neighborhoods, especially on young men in urban centers. Okay, well, in other words, it's important to keep in mind and remember that frisks are searches of persons, but they are to be an external clothing search only. It's just a little slight feel of it. Warrantless searches do come under the Fourth Amendment, and there have to be two requirements that are satisfied. There needs to be some kind of a need that outweighs the invasion of privacy, and then also there have to be some facts to back this up. In other words, it can't just be a pure hunch, just a whim, something like that. There needs to be something that triggers police officers' interest. Like we said in the case of Terry, it was the coat. Well, let me ask you a question. If a police officer came to you and you were in your car and said they wanted you to get out of your car and submit to some kind of a frisk, how would you feel about that? Would you think that was fair, or was it reasonable? What do you think the court would do with that if you said no or if you said yes? Either way. Well, here's a case we need to look at, and then this is a case, Scott versus Harris. Scott versus Harris. It's a 2007 case. I don't have a full citation to it right now. I'll have to look for it later, and I'll put it up there. But it's 550 U.S., so that's the volume number. I just don't have a page number here. It's a 2006 case. Police officer attempted to pull over Harris. He took off in his car. Police officer engaged in a high-speed car chase. Attempting to end the chase, the officer rammed Harris's car with the police cruiser. Harris crashed and was rendered a quadriplegic, so he had no use of his arms or legs. Harris sued in federal court alleging that his rights were violated, and the police officer argued for qualified immunity. And he was acting in his official capacity, but the district court rejected the police officer's claim of qualified immunity. Issue there is, they had to violate a clearly established constitutional right. The 11th Circuit ruled that Scott's actions constituted an unreasonable seizure. In other words, he went too far. Basically, because you can run his license plate, and you can just look it up online, and you can find the person easily and just go to their house and catch them. So why do you have to run them over the road, knock them over, and cause them to be rendered a quadriplegic. Now, it's obviously use of deadly force. It's kind of like a case we're going to talk about later on called Tennessee versus Garner. So the police officer, however, appealed this decision that was rendered in the 11th Circuit and indicated that no, in an 8-1 ruling, Scott's actions were reasonable. In other words, yeah, you can run a guy off the road and knock his car over, even though you don't have clear evidence, you know, to arrest the guy. Whereas what they're saying is that in the videotape of the car chase, said the police made every effort to you know, stop the individual, that he was not being reasonable in his driving, that he was being highly unreasonable. So basically, you know, his argument that they violated his rights was brushed aside by the U.S. Supreme Court. Obviously, you know, I have really questioned that. I mean, there's got to be a limit. Like I said, there's other things that you can do other than run the guy off the road. Frankly, police officer ramming a car like that, a lot of times police officers get hurt really bad. So he's really lucky that he wasn't injured. But here again, here's a good opportunity for you to argue, you know, police officer was right in doing what he did. Someone else may want to say, no, police officer was wrong in doing what he did. What do you think? Put that in your discussion. That'd be a good point to discuss. So here again, that case, if you want to look it up, is Harris. It's Scott versus Harris in this particular case, 550 U.S., but I don't have the page number. I will find it. And this Scott was the police officer and Harris was the defendant. So in the case of the civil suit, though, Harris became the plaintiff. So look it over, see what you think, let me know. We'll be doing more of these, as you know, and so hope you enjoyed it, and I'll be back with another one soon.